the most horrifying things that could potentially happen as an author is to have your book plagiarized. And if you discover that your novel has been plagiarized by someone else, we need to talk about the steps you need to take in order to protect your copyright and make sure that the other person stops their offense against you. Today, we're going to talk to everyone's favorite IP and entertainment lawyer, Tony, for more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called the IP Professor that's dedicated to all things intellectual property.
We've talked a little bit about what happens when our books are plagiarized, Tony, and how to make sure we protect ourselves, how to make sure we've got that copyright in place. But I want to talk about steps to take once we discover our book has been plagiarized out in the world. So what do we need to know about this?
So first thing, don't panic. I think that getting in a very manic state is a natural reaction, but I think going into the process of addressing some type of plagiarism is, it's important to have some type of cool, collected, level-headed response. So I think first, maintaining emotions is imperative. Then I would say the next step is to get every receipt you possibly can. So get screenshots, get captions, whatever information that you can collect that can show blatant information of plagiarism, blatant evidence of infringement or plagiarism is really going to be a vital part of the process, because then the next step would be to contact a lawyer that specializes in the copyright infringement space. I think working with them and getting an idea of, what type of cause of action you have, what's the likelihood of success with it, so on and so forth. I think they can give you the best advice. I would say the 3A part to that is, this is all going to depend also primarily on whether or not you have a registered copyright with the U.S. Copyright Office. Because if your book was, and clearly there's been some type of evidence of infringement by somebody else, then you know that going to the lawyer is being a productive conversation. But then to that 3B, the second part to the third step of going to a lawyer, it's all going to depend on how much infringement took place. Like, is it even worth our while, so on and so forth. So I'll give you, kind of lay out like why I'm saying that. The U.S. Copyright Office now just enacted, thanks to the CASE Act, this new, essentially a small claims court that exists under the purview of the U.S. Copyright Office, the Copyright Claims Board. You can bring a copyright claim to that court for basically two claims up to $15,000 each, so an aggregate of $30,000. That's a nice cost-effective way if you don't really want to go through the legwork of buying an index number, going through federal court, It's smooth, clean, simple. Now, it is new, so I can't speak to necessarily the response time for a copyright claims board, because it's fairly new in its infancy. It only just went into effect a few months ago. But that said, that is a way that it's a cost-effective way for all parties to address that copyright infringement matter. It certainly can be a very effective way to get a quick remedy, hopefully. But also it's a fairly seamless process. On the flip side, if you're adamant, and even on the advice of counsel, they think that going to federal court is the way to go, then you could go to federal court, but the damages you're looking at is a maximum of $150,000. That's codified in the Copyright Act. It's pretty much cut and dry. So, I hate to make it sound like this, but it's a matter of not just efficiency and simplicity, but it's a matter of, are you greedy? Do you want $50,000 or do you want $150,000? I would say that you shouldn't go into that necessarily with the high dollar amount as like the top priority. I would say the priority should be an enforcement of rights. You're enforcing your rights and you're trying to protect those rights. Mm-hmm. So I think once you kind of have worked with a lawyer, seeing what they say, it's really going to be a matter of just, at least what I would hope, some type of mitigation tactic. So maybe not on the onset starting with a complaint, but maybe starting with a cease and desist letter. Hey, we learned of this infringement. My client, and this is what I would suspect the lawyer on your behalf would write. My client is the copyright owner of this specific book or this specific manuscript. This is the registration number in the U.S. Copyright Office. We became aware of your use of their copyrighted material. Please cease and desist all matters. So maybe you can make it kind of simple that way. Basically creating some type of peace bridge, if you will. And if it becomes a very hostile situation, then maybe your lawyer at that point will have to escalate the matter. So bottom line is that I think is the foolproof way to address it. I think that that's kind of the realistic way of approaching plagiarism in that context. But again, every lawyer is different. Every fact pattern is different. So whatever I'm sharing here is just a hypothetical, what should ideally happen. But I would strongly urge you to go to a lawyer and ask for their advice, because at the end of the day, like I said, your situation is probably going to differ from Susie Q's situation of infringement. That's also going to differ from John Smith's situation with infringement. Plus, the dollar amounts may be different. There are a lot of factors that are going to come at play. Even your lawyer's mindset may be different. There may be more of a shark as opposed to being a more compassionate human being. So having close contact with a lawyer and working with them intimately on that process is going to be an imperative part of that process.
So we want to make sure that if we discover someone has plagiarized our stories, we are first confirming that there really is plagiarism going on. We want to make sure we have all that evidence. Then we want to gather that evidence together. We want to make sure we have all the receipts so that we can go to our lawyer, present our case, and they will be able to guide us through those next steps depending on what we want to pursue and what they think is a wise path to pursue with protecting our copyright inside of our stories. Tony, any other thoughts on this?
Just one other thing that, again, it's a matter of having everything and anything readily available for your lawyer to see. So I think you can't just go off of hearsay in a situation like this. Having the hard, cold evidence that shows infringement is going to be equally part of the process. One other thing to bear in mind is I think this underlines all the more how infringement can happen to anyone. So if you're watching this and you've never had an infringement issue whatsoever, don't risk it. Don't say to yourself, "Oh, I'm never gonna get my work is never gonna be infringed on." You just don't know that. So I think being proactive and registering your manuscripts, your works of authorship in the Copyright Office on a consistent basis as you produce more copyrighted material is just going to afford you a better opportunity in the long run of getting your work protected. And then when that infringement comes, you have the foolproof evidence that you are the copyright owner. And that's the only way you can bring a copyright infringement claim anyway. You have to have the work registered in the Copyright Office. If there is no registration, there is no claim. You just can't do it. That case law and statutory law has made that abundantly clear. So if you're watching this, be mindful. It's never too late to register your works in the Copyright Office. They're cheap, and in the long run, it's what's worse, losing out on tens of thousands of dollars that could be a good copyright infringement claim, or $55 in the Copyright Office. It's the cost benefit analysis is so clear here. It's just worth your while to register in the Copyright Office.
And if you need more information on that, we've actually done other episodes on this. We'll link those down below for you to make sure you are staying legally protected inside of the publishing industry. If you've got more questions, go ahead and drop those down below. And you can reach out to Tony on his social medias, where he is dropping so much knowledge to make sure that we are safe and protected inside of the publishing industry or whatever industry you happen to be working in. So Tony, where can everybody reach out to you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And like I said before, I cover a bevy of different topics on the IP space. But if you have any questions related to a video I've talked about or something new, you can always reach out to me in the DMs.
Hit that subscribe and notification bell, because every single day we are dropping new episodes to help you level up in the writing and reading world. And Tony is coming back to answer more of your questions to keep you legally protected inside of the publishing industry. Make sure you drop your topic suggestions down below and any questions you have, and we'll see you in the next episode.